Established in Article 2, Section 1 of the U.S. Constitution, the Electoral College is the formal body which elects the President and Vice President of the United States. Each state has as many electors in the Electoral College as it has representatives and senators in the United States Congress, and the District of Columbia has 3 electors. When voters go to the polls in a presidential election, they actually vote for the slate of electors who have vowed to cast their ballots for that ticket in the Electoral College. Electors. Most states require that all electoral votes go to the candidate who receives the most votes in that state. After state election officials certify the popular vote of each state, the winning slate of electors meet in the state capitol and cast 2 ballots, one for vice president and one for president. Electors cannot vote for a presidential and vice presidential candidate who both hail from an elector's home state. For instance, if both candidates come from New York, New York's electors may vote for one of the candidates, but not both. In this hypothetical scenario, however, Delaware's electors may vote for both New York candidates. This requirement is a holdover from early American history when one of the country's major political fault lines divided big states from small states. The founders hoped this rule would prevent the largest states from dominating presidential elections. Maine and Nebraska employ a district system in which 2 at-large electors vote for the winner of the state's popular vote and 1 elector votes for the popular winner in each congressional district. Although it is not unconstitutional for electors to vote for someone other than those to whom they pledged their support, many states, as well as the District of Columbia, bind electors to their candidate using oaths and fines. During the 19th century, faithless electors, those who broke their pledge and voted for someone else, were rare, but not uncommon, particularly when it came to vice presidents. In the modern era, faithless electors are rarer still, and have never determined the outcome of a presidential election. There has been 1 faithless elector in each of the following elections: 1948, 1956, 1960, 1968, 1972, 1976, and 1988. A blank ballot was cast in 2000. In 2016, 7 electors broke with their state on the presidential ballot and 6 did so on the vice presidential ballot. Procedure. Since the mid-20th century, Congress has met in a joint session every 4 years on January 6 at 1 p.m. to tally votes in the Electoral College. The sitting vice president presides over the meeting and opens the votes from each state in alphabetical order. He passes the votes to 4 tellers, 2 from the House and 2 from the Senate, who announce the results. House tellers include 1 representative from each party and are appointed by the Speaker. At the end of the count, the Vice President then announces the name of the next President. With the ratification of the 20th Amendment to the Constitution, and starting with the 75th Congress in 1937, the electoral votes are counted before the newly sworn-in Congress, elected the previous November. The date of the count was changed in 1957, 1985, 1989, 1997, 2009, and 2013. Sitting Vice Presidents: John C. Breckinridge, 1861, Richard Nixon, 1961, and Al Gore, 2001, all announced that they had lost their own bid for the presidency. Objections. Since 1887, 3 U.S.C. 15 has set the method for objections by members of Congress to electoral votes. During the joint session, lawmakers may object to individual electoral votes or to state returns as a whole. An objection must be declared in writing and signed by at least 1 representative and 1 senator. In the case of an objection, the joint session recesses and each chamber considers the objection separately for no more than 2 hours. Each member may speak for 5 minutes or less. After each house votes on whether to accept the objection, the joint session reconvenes and both chambers disclose their decisions. If both chambers agree to the objection, the electoral votes in question are not counted. If either chamber opposes the objection, the votes are counted. Objections to the Electoral College votes were recorded in 1969, 2005, and 2021. In all cases, the House and Senate rejected the objections and the votes in question were counted. Amending the process. Originally, the Electoral College provided the Constitutional Convention with a compromise between two main proposals, the popular election of the President and the election of the President by Congress. Prior to 1804, electors made no distinction between candidates when voting for President and Vice President. The candidate with the majority of votes became President and the candidate with the second most votes became Vice President. The 12th Amendment proposed in 1803 and ratified in 1804 changed that original process, requiring electors to separate their votes and denote who they voted for as President and Vice President. See Electoral College and indecisive elections for more information. The District of Columbia has had 3 electors since the 23rd Amendment was ratified in 1961. There have been other attempts to change the system, particularly after cases in which a candidate wins the popular vote, but loses in the Electoral College. 5 times a candidate has won the popular vote and lost the election. Andrew Jackson in 1824, to John Quincy Adams, Samuel Tilden in 1876, to Rutherford B. Hayes, Grover Cleveland in 1888, to Benjamin Harrison, Al Gore in 2000, to George W. Bush, Hillary Clinton in 2016, to Donald J. Trump. The closest Congress has come to amending the Electoral College since 1804 was during the 91st Congress, 1969 to 1971, when the House passed H.J. Res. 681, which would have eliminated the Electoral College altogether and replaced it with the direct election of a president and vice president, and a runoff if no candidate received more than 40% of the vote. The resolution cleared the House 338 to 70, but failed to pass the Senate. Contingent elections. In the case of an Electoral College deadlock or if no candidate receives the majority of votes, a contingent election is held. The election of the President goes to the House of Representatives. Each state delegation casts a single vote for one of the top 3 contenders from the initial election to determine a winner. Only 2 presidential elections, 1800 and 1824, have been decided in the House. Though not officially a contingent election, in 1876, South Carolina, Florida, and Louisiana submitted certificates of elections for both candidates. A bipartisan commission of representatives, senators, and Supreme Court justices reviewed the ballots and awarded all 3 states' electoral votes to Rutherford B. Hayes of Ohio, who won the presidency by a single electoral vote. Americans have never voted directly for president. The U.S. Constitution specifies that state electors, not everyday citizens registered to vote, elect the president and vice president. It's those presidential electors registered voters choose on election day. Together, those electors make up the Electoral College. When registered voters choose President Donald Trump or former Vice President Joe Biden or another candidate on November 3, what they're really doing is telling nominated electors, I want you to vote for this person for president. Whichever candidate wins a state's popular vote, it's their party's slate of electors who get to then vote for president. The candidate who receives a majority of electoral votes, 270 out of 538, wins the presidency. The varied suite of state laws governing how presidential electors are nominated and cast votes is available from the National Association of Secretaries of State. 32 states require that their electoral votes go to the candidate who wins the statewide popular vote. Electors who snub the popular preference face fines or criminal charges in a few states. Electors typically vote for president at their state capital roughly a month after Election Day. Individual Secretary of State offices can answer questions about whether voting by presidential electors is open to the public. Maine and Nebraska are exceptions to the winner-take-all electors rule. Those states have what's called a district system. 2 electoral votes go to the statewide popular vote winner. Then there's 1 electoral vote for each congressional district, appointed based on the vote winner within the district. There are 3 congressional districts in Nebraska and 2 in Maine. In 2016, 3 of Maine's electoral votes went to Hillary Clinton and 1 electoral vote from its 2nd congressional district went to Trump. The U.S. has what's called decentralized voting. That means while there are federal agencies that do things like enforce campaign finance laws, there's no federal agency or bureau that runs presidential elections. That job is left to individual states. The national census taken every 10 years determines each state's number of representatives in the House of Representatives as well as each state's number of electors who vote for president. The number of presidential electors in a state equals the state's total number of representatives and senators. The District of Columbia gets 3 electors. Processes vary for nominating electors. The Constitution doesn't say how state legislatures should nominate electors, and each state determines how it does so. In modern presidential elections, political parties in each state nominate electors through a variety of formal and informal processes during the spring and summer of an election year. Electors are usually active and loyal party members, so they're expected to vote along party lines. The way it works oftentimes is that the major party organizations within a state, Republican and Democratic, nominate a slate of electors prior to election day and send those names to the Secretary of State's office. Some states require that electors be eligible voters, or registered to vote, or that they take an oath to honor their state's popular vote results. Members of Congress cannot serve as presidential electors, but they choose the president and vice president if no ticket reaches the 270 threshold. Historical practice dictates that presidential electors vote for president according to their state's popular vote results. Faithless electors, those who vote contrary to the popular vote count, have never decided the presidency. 5 times the Electoral College winner and eventual president lost the national popular vote: 1824, 1876, 1888, 2000 and 2016. Electors in Michigan and Utah who vote contrary to their state's popular vote results automatically lose their position and are replaced. Faithless electors in New Mexico risk felony criminal charges. The U.S. Supreme Court affirmed in July that states have the right to put in place enforcement measures to ensure electors vote for their party's nominee, if she or he wins the popular vote. Ciovallo v. Washington centered on 3 electors in Washington who violated their pledges to support Hillary Clinton in 2016, voting instead for former Secretary of State Colin Powell. The state fined each elector $1,000. Justice Elena Kagan wrote the opinion of the court, offering that the fines reflected a long-standing tradition in which electors are not free agents, they are to vote for the candidate whom the state's voters have chosen. To recap, when voters make their choice for president on election day, they're really voting for the slate of electors put forward by the political party their candidate belongs to. States don't typically put nominated electors' names on presidential ballots, but those names are a matter of public record. Know your electors. In most presidential election years, the presidential candidate who wins the popular vote in a state is virtually guaranteed to get that state's electoral votes. In 2000, Florida's then 25 electoral votes weren't certain to go to former Texas Gov. George W. Bush until mid-December. In a ruling that legal scholars would hotly criticize and analyze for years, the Supreme Court halted a recount in the state, reasoning it would have been impossible to continue the recount while meeting a key electoral deadline required by federal law. More on electoral deadlines below. The ruling allowed to stand the Florida Secretary of State's certification of the election in favor of Bush. Florida's 25 Republican presidential electors were the ones elected following the court's ruling. They then voted for Bush, who prevailed in winning the presidency with a total of 271 electoral votes. Who electors are becomes relevant during an election season like the current one, in which the president refuses to agree to a peaceful transfer of power if he loses, and during which at least one of his campaign advisors appears to be gaming scenarios to replace electors in politically friendly states after the November 3 election and contrary to the will of the voters, according to reporting from The Atlantic's Barton Gellman. In the Atlantic piece, "The Election That Could Break America," there's a specific focus on Pennsylvania, where 3 Republican leaders told me they had already discussed the direct appointment of electors among themselves, and one said he had discussed it with Trump's national campaign, Gellman writes. Some Republican legislators in Pennsylvania resist the notion that such an arrangement might be on the table, according to reporting published in the York Daily Record. A report from the nonpartisan National Task Force on Election Crises maintains it would violate federal law for a state legislature to appoint electors after Election Day. There's no final word here. The Supreme Court has never had opportunity to weigh in on this exact situation. The Electoral Count Act of 1887 specifies the process for electoral voting after Election Day, but its language is ambiguous. The Act is the closest thing to a roadmap for handling controversies after Election Day, and on many issues, it offers helpful guidance, writes Harvard Law School professor Cass Sunstein in a recent working paper, Post-Election Chaos, a primer. He continues, at the same time, it is not at all clear that it is constitutional, or that it is binding, and in the face of a claim of serious mistakes and fraud, it contains silence and ambiguity. Each state has a constitutional right to direct how it appoints its electors. The Supreme Court in 1932 decided a case related to state legislative authority over holding congressional elections. The court in 2015 reaffirmed the central findings of that case. For the purposes of the coming presidential election, the majority opinions in those cases would likely dictate that state legislation attempting to modify how electors are chosen would be subject to gubernatorial veto. In a state with a Republican legislature and a Democratic governor, or the reverse, such legislation would almost certainly be vetoed. But justices change, and the court may change legal interpretations over time. Because Trump has repeatedly said that he won't accept the election results if he loses, there is a not zero chance the Supreme Court will decide the presidential election in 2020 as it did in 2000. With countless potential unknowns before and after November 3, including that the President and First Lady have COVID-19, who the nominated electors are again becomes relevant. There are a baker's dozen swing states that Trump and Biden each have a reasonable chance of winning. Arizona, Florida, Georgia, Iowa, Michigan, Minnesota, Nevada, New Hampshire, North Carolina, Ohio, Pennsylvania, Texas, and Wisconsin represent 199 electoral votes, among them 37% of the 538 total electoral votes and 74% of the 270 needed to win the presidency. They are the battlegrounds that will decide the 2020 presidential election, according to data analysis and reporting from the Associated Press, 538, NPR, and the New York Times. A state's office of the Secretary of State is the usual place to turn for names and contact information for presidential electors. Some Secretary of State offices, like in Georgia, publish contact information and occupations for some electors on their website. Other states, like Florida, offer only names. Most of the 2020 swing states don't make nominated slates of electors readily available online. For the reasons stated above, namely that there is a host of evidence that fall 2020 is shaping up to be an extraordinary presidential election season, Journalists Resource is compiling the names of electors in these 13 swing states. For states that don't make electors' names available online, we obtained other records, such as official presidential nomination papers, which include names of presidential electors and, in some cases, personal information, such as home addresses. Some electors are public figures: mayors, state legislators, former high-level state office holders, former presidential cabinet members, and so on. Others are primarily private citizens who, despite potentially holding a public position in this instance, may also have a reasonable expectation of privacy. For this reason, and considering the FBI has warned of violence before and after November 3, we have chosen only to publish electors' names. American voters have come to expect a presidential result on election night or, at latest, early the next morning. Media outlets like the Associated Press notably make those calls based on reams of data and reporting from across the country. For the coming presidential election, 3/4 of voters will be able to vote by mail, meaning tens of millions of ballots may go uncounted until days or weeks after November 3. Given the likely delay in the vote count, Americans shouldn't expect a clear presidential winner come November 4, barring an overwhelming victory for either Trump or Biden. If media outlets do call the presidency on election day or shortly thereafter, audiences shouldn't construe those calls as official results. State election officials will still need to certify the general election results, and the Electoral College vote for president doesn't happen until December. The whole goal here with respect to the presidential election is to have the state rules for counting the popular votes in the state lead to the Electoral College process, explained Ned Foley, who directs the election law program at The Ohio State University, during a recent media briefing hosted by the National Task Force on Election Crises. And if we don't have a result on election night, or the next day or even the next week, that's not a problem. That's not even a delay. Key election cycle dates. Here are the key dates for the 2020 U.S. presidential election cycle. November 3rd, Election Day. Either on this day or through absentee or early voting, registered voters will choose the candidate they want their electors to vote for. December 8th, the last day for states to resolve disputes over vote totals. If state disputes aren't resolved, Congress decides which slate of nominated electors gets to vote for president. Congress, it should be noted, is split between Democrats, who control the House, and Republicans, who control the Senate. December 14th, electors meet in their respective states and cast separate votes for president and vice president. Copies of the vote results go to the vice president, who also serves as president of the Senate. January 3rd, the newly elected Congress is sworn into office. January 6th, Congress meets in a joint session of the House and Senate at 1 p.m. to count the votes cast by presidential electors. The vice president opens the results by state in alphabetical order. There are procedures for deliberation and objection. If the counting isn't done by the end of the day, the chambers can break. If results are still being debated come January 11th, Congress can't take any more recesses. January 20th, the 4-year terms of the incumbent president and vice president end at noon. The president-elect and vice president-elect are sworn in. If the election results remain in dispute, the Speaker of the House becomes president until those disputes are resolved. Thank you for watching this video.